Recording. Okay. Makeup, please. Okay, so here we are in Admiralty Law, Section 2, fall of 2025. I'm Jim Maloney, and this is Module 1. The first class we had, I'm calling Module 0. We talked, we didn't record. So the people who come into this class later, or the people who want to review it from either section, will have this video to do it with. So let's begin with what we started talking about last week. Sources of law. Where does law come from? Well, law comes from the government, right? I mean, first of all, you can believe that law comes from divine powers, but for purposes of, the law we're going to deal with, it comes from government. And which branch of the three makes the law? Let me get two of these so I don't have to keep popping into the camera. I'm back. So we have three branches of government, and they are known as legislative, executive, and judicial branches. And this is a weak marker, so we'll try to do that with something darker. Still pretty weak. I'm not sure I like the back of my head exposed like that. We'll go back with the cap. Anyway, we'll try this again. I can always edit. Look at that. So, of these three, which one is traditionally the source of lawmaking authority? Legislative, executive, or judicial? Yes?
The judicial?
No. That would be the case to some extent in Admiralty, and that's why you're thinking that, because I said Admiralty law is unique because a lot of law that's made, a lot of Admiralty law is made by the judges, and that's unusual. Typically, and somebody's going to raise their hand, but we'll just jump to the thing here, the legislative branch. In the United States government, that would be Congress, and in state government, it would be the New York legislature, at least in New York, and it's usually two houses, a Senate and an Assembly, or a Senate and House of Representatives. I'm just going to double check that these are all coming in. Yeah, just makes it good. Okay, so typically in any government system, whether it's state, federal, or some other nations, if you have separation of powers, meaning if government is divided into three separate powers, three separate sources of authority, these are the big three, You have the lawmakers, the legislative, you have the executive, which, executes the law, applies it, and the judicial branch, which is the courts, which basically interprets the law, and they apply it too in a case-by-case way. One of the things I mentioned, and I just brought it up again, that makes Admiralty a unique area of law is that Admiralty law, unlike any other area of federal law, is in large part made by the judges. The legislature doesn't generally make the law. It has been passed on from generation to generation, and it evolves as it goes. But our Admiralty law, our body of Admiralty law, it's not entirely made by the judges. Congress has stepped in and done stuff. But it came here with the original colonies from England. And they applied rules that had been around in England for hundreds of years. And those rules had gone back to these Mediterranean shipping codes from the 1st century CE. By the way, an aside here, and it's worth putting on video. Does anybody know what CE means and why you say CE instead of AD? They mean the same thing. Anybody? Okay. So the idea is that AD, being Latin, stands for Anno Domini, years of our Lord. And so it's somewhat culturally biased. So if you're not Christian, it would be, maybe a little bit less than politically correct to say it that way. So we have CE, which means common era, meaning after the year 1, right? Which, they're interchangeable, but I guess the more correct modern version is to say CE. What about the before? BC. Used to be BC for before Christ. The equivalent is BCE, before the common era. But when you say that one, if you just rolls off your tongue, nobody even knows you're saying BC or BCE. That happened in 25 BC. BCE or BC? Doesn't matter. They mean the same thing. AD and CE come out differently. Anyway, the point of tangency here is that the Mediterranean Sea codes, which included all these very complex written codes, the rolls of Oleron, the tablets of Amalfi. These were evolving in Mediterranean shipping back in the 1st century CE, or the 1st century AD. And they became very much a part of international maritime law, commercial law on transactions, carriage of goods, rights of seafarers. All this stuff was actually thought about more than 1,000 years ago, you know, and put down on paper, or actually sometimes on tablets, stone tablets. This got passed on. All these maritime nations would continue to use this, and the judges would apply it. And right up until the present day, there's a whole body of maritime law that comes from that history and judge-made law, because the judges, apply these principles that have been around for centuries, and there's no statute that says, these are the rules relating to maintenance and cure, these are the rules relating to salvage. There isn't even one that covers marine insurance. There's no federal marine insurance statute. There is one in England, but there's none in the United States. So a lot of this stuff is judge-made law. And Admiralty is the only area of federal law where the substantive law is so much developed and created by judges. Everything else, the legislature does the legwork, right? In fact, that's a good metaphor. I never thought of that. Legislature. And then the judiciary just interprets it. But in the case of Admiralty, it began with the judiciary, and now Congress has stepped in and added more to it. And I gave you the example. Does anybody remember the example I gave of a statute that arose out of a certain casualty before any of you were born, before I was even admitted to the bar? The Oil Pollution Act of 1990 is exactly what you were going to say. I knew that. I was reading your mind. OPA 90, OPA 90, occurred after the Exxon Valdez grounding in Prince William Sound in Alaska, and it was Congress's attempt to try to limit marine pollution from tankers. And there are many examples of Congress legislating in the area of maritime law, but there's still a lot of it that is not touched by Congress. I gave you a few examples. I guess the big one we're going to get to later is marine insurance. Congress, back in the 20th century, mid-20th century, 1940s, basically said, we're not going to regulate insurance. We have the power to do it, but we're not going to do it. We'll leave it to the states, which is great when it comes to homeowners insurance and life insurance and auto insurance. With marine insurance, it becomes a little bit of a problem because we hope to have uniform law, and if the laws of the states are going to apply, they could be different in case by case. We'll examine that in more detail later. But just something to keep in mind in the context of marine insurance going forward, there is no statute in the United States that comprehensively explains who has what right and what has to happen. Some of it is judge-made law, and some of it they look to state statutes. And the question of which applies when is a very complex one that we're going to touch upon in this course later when we get to marine insurance. But the bottom line here is that Admiralty is something very different from all other areas of federal law because of the fact that the judges have made so much of it. They actually have created it, and they still have a right to create new rules of law in Admiralty, whereas in other areas of law, people would criticize the judges as being activists. So you don't get to legislate, Your Honor, that's up to Congress. In the area of Admiralty, they do get to legislate. They don't do it as much as they should sometimes. Maybe they should do it more often in marine insurance, but that's only my personal bias. But anyway, the bottom line is Admiralty is unique in that regard. So now let's talk about something I uploaded to Brightspace a couple of hours ago. And it's not an assignment at this point. It will be important reading down the road, but my feeling is that today is what, the 27th, right? And Labor Day is the 1st. So, and I'll say this right on video, I don't think we really should be here yet. But anyway, bottom line is there are no assignments until after the first class. I'm sorry, the first class after Labor Day, which will be your third class. And that will be on Wednesday, a week from today. In the meantime, though, I have uploaded these two documents, and they're really just 2 pages each. There's something I wrote 9 years ago when I first started teaching here. One is just a glossary of terminology, and I encourage you, I'm not assigning it, but I encourage you to look at that terminology over the break and be familiar with some of those words. If you don't do it then, do it later. Certainly you want to do it before the first test, right? But, bottom line is, it's not an assignment yet, and I don't know, I feel like I'll put stuff up there and I'll try to make it clear if there's something that's just optional. But anything that doesn't say just optional, consider it an assignment. I'll try to keep it brief. But anyway, that's one of the two that I uploaded. It's a glossary. The other one is, well, I'll get to the other one later. Because what I want to talk about with the glossary is a couple of words that I left out deliberately. I made a considered decision back in 2016 not to include two words in there that should be included. But if I was going to include them, instead of being a 2-page handout, it might be, I don't know, could be a 10-page handout. Because they're words that require a lot of explanation. So I'm going to tell you what those two words are. I'm going to write them down, and we're going to see if people have an idea of what they mean, and then we're going to talk about what they mean. So this will be on video. I think just for sake of having a clean screen, we'll erase it, and I'll write these two words down, and then we'll talk about them. These are the two words that are not in the glossary that I uploaded today. Tort and jurisdiction. And this one by far is, that arrow won't come out. The purple lines are the limits of the camera. But anyway, jurisdiction is a lot more complicated. Tort, I just wanted to mention because it's something that it's better if we talk about than if you try to see a canned definition, that explains it. So those of you who've had business law, or those of you who studied this in high school, or maybe, just have been involved in lawsuits, perhaps, anybody want to tell me what a tort is? I'm not talking about the pastry here. We're talking about a legal concept. Anybody?
For wrongdoing?
Yeah. But so is a crime. What's the difference? Why is a crime wrongdoing? Go ahead.
Civil.
Exactly. Civil versus criminal. So if you, best example I have is, I go up to somebody and I punch them in the face. That could be an assault under criminal law. And I could be, charged with a crime and punished, maybe, pay a fine or do some time, whatever. But that's the criminal side of it. But the same act, hitting somebody in the face intentionally, could be what's called a battery under tort law. And the victim could sue me for having committed an intentional tort and committed a battery on him. I hit that guy in the face and he's going to sue me for knocking out a tooth. And he's got damages, dental bills, and disfigurement, whatever. It could be a lot of money. But the difference, it's the same act, but it can be both a crime and a tort. But of course, torts are broader than that. They can include unintentional torts. And the classic example of unintentional tort, you didn't mean for anything to go wrong, but something went wrong. What do we call that?
Negligence.
Negligence, exactly. Negligence is the big tort out there, right? Because if somebody has a duty to prevent creating an unsafe condition or problem, the sidewalk in front of their house or maybe something on a ship, and somebody gets hurt as a result, and they had a duty not to let that happen, and they breached that duty, they failed to prevent the harm, a foreseeable harm, that is negligence. And you can recover for that as a plaintiff, you can get money. So these are torts. Now why is that important? Before we go on, any questions about that concept? Okay, I will give you a quick aside. When you go to first-year law school, and some of you probably will, you will usually have courses in contracts and torts. And those are usually talked about in contradistinction. In other words, there's a case you have, and is it a contract case? Well, if the two parties had an agreement, then it's a contract case. And if there was no agreement between the parties, it's often a tort case because, there was no agreement between the parties, but somebody owed somebody a duty independent of the contract. There is an overlap, but I don't want to go too far off on that tangent. The reason I mention it is because when we get to this issue, jurisdiction, contract and tort become important distinctions for the question of whether a court can hear a case. So we'll get to that in a few minutes. Let's talk just a little bit more about torts. I said earlier when I gave the example of the battery, which in criminal law is called an assault, in civil law, at least in New York, it's called a battery. You physically harm somebody. Offensive or harmful touching is I think the definition under the New York statutes. But the bottom line is that that's an intentional tort. There are intentional torts and unintentional torts. Can anybody give me another example of an intentional tort besides a battery? You intentionally do something to somebody and they can sue you for having done that. Yes?
Fraud.
Fraud. Anybody else? How about false imprisonment? If you lock somebody in a place, you don't touch them, but they're in a room and you lock them there and you don't let them out for 3 days. That's also another tort. Another big one, which people don't think about that much until they become the victim of it, I guess, is libel or slander, defamation, right? So if somebody says or publishes something about you that is intentionally false, you can sue them for, if it's published, it's libel. If it's spoken, it's slander. But those are also intentional torts. Unintentional torts, the big one is negligence. In the Admiralty context, really the only one that gets litigated a lot, I mean, a lot, is negligence. But Admiralty does recognize, intentional torts as something that can be compensable. So, for example, if I assault a fellow crew member, hit a crew member, I might be able to be sued in Admiralty for that. But that's a bit of a tangent. Anyway, let's move on from tort to this other word that I excluded from the handout, and that is jurisdiction. So who would like to take a stab at explaining what that means? What is jurisdiction? Anybody?
You're a little bit of power over a certain situation or geographical situation.
Yeah, and it really depends on whose jurisdiction we're talking about. One of the common examples that people think of, and we're not really going to go there too much, is the idea that, let's say you're driving on the highway and you cross from, New York to Vermont, and a New York State trooper pursues you over the state line and wants to give you a summons, and you say, hey, officer, you have no jurisdiction, you're in Vermont, right? That's the concept. I'm not even going to get into the question whether that state cop would have jurisdiction over you in Vermont. But the same thing applies with other sources of authority besides cops, namely the ones we're concerned about. I don't have the J there anymore, but the courts. The courts have to have jurisdiction in order to hear a certain case. And this is where it gets a little complex. And we're going to examine it beginning today, and we'll revisit it. I don't expect people to have total mastery over the concepts of jurisdiction, but I do want to introduce it because it's a very important thing in Admiralty, and it's not an easy thing to get your head around. So I'm going to kind of visit it in stages. First off, and this is a good thing to draw pictures with as you go. So we're going to get rid of tort, and we're going to talk about jurisdiction, but we're actually going to make jurisdiction the header here. And now we're going to subdivide it. And we mean the court's jurisdiction. Two important considerations, in federal court at least. One, which is true in state court as well, is there has to be personal jurisdiction. And in federal court particularly, so I'll put federal in parentheses, there has to be subject matter jurisdiction. And we're going to come back to that, but yeah, that's fine. So let's look at this part first. Personal jurisdiction. That means that the court has to have jurisdiction over the defendant, right? I can't just sue somebody in China and say, in New York and say, this guy in China, he did some bad thing and I want to sue him. Or a company in China, for that matter. There may be a basis for having the jurisdiction over that foreign person or corporation, but you have to examine it and see if it's present. The idea here is that the court just can't have jurisdiction over anybody, any company, any person, any ship, anywhere, at any time. There has to be a reason why the court has jurisdiction over that party. Now, a question for you, a thought question. The court has to have jurisdiction over both the plaintiff and the defendant, right? But you always worry about whether they have jurisdiction over the defendant. Why don't you worry about whether they have jurisdiction over the plaintiff? You're suing somebody in court. You're the plaintiff. Have you consented to let the court have jurisdiction? Well, if you're suing them, of course. So jurisdiction questions, personal jurisdiction questions, always go to the issue of whether there's jurisdiction over the defendant. It's assumed that the court has personal jurisdiction over the plaintiff because the plaintiff has wanted to avail himself, herself, or itself, if it's a corporation, of the court's power. So they're consenting, implicit, implied, whatever you want to call it, they're consenting to the court's personal jurisdiction over them. Now, defendants, it's a whole complex set of questions about whether the court has personal jurisdiction over a given defendant. And we're not going to examine all those now, and we're probably not going to examine them very much in the whole course. But, you know, there are questions of whether the transaction related to the forum where the court sits, or whether they're citizens, or whether they have presence there. And when you get into things like jurisdiction over a vessel, there are other considerations that we're going to examine. But I just wanted to get into that prong there, because jurisdiction in federal courts requires jurisdiction over the defendant, but also another kind of jurisdiction, the one I have here on the right, subject matter jurisdiction. In state court, this doesn't matter that much, at least not in New York, and probably not in most states, because most of the courts in the states are courts of general jurisdiction, meaning they can hear any case about anything. If somebody wants to bring a case in New York Supreme Court, which is the lower court, they can do that. And they can do it on any topic, any subject, you know. And generally speaking, the court will have jurisdiction over that subject matter. Whereas in federal courts were created by the Constitution, which, by the way, is my other handout, but it doesn't talk much about the courts. Anyway, we'll get to the other handout, the one I put on a bright space. Anyway, bottom line is subject matter jurisdiction has to do with whether the federal court can hear that type of case. Okay? In other words, federal courts are not courts of general jurisdiction. You can just go into court and complain about anything. You have to tell the court, in fact, you complain, at your first pleading, you have to state what the basis is for the court's jurisdiction. And those bases, by the way, basis pluralizes to bases, but it's a long E. This would be like baseball bases, but if it's long E, it's bases. That's the plural of basis. So federal courts have a number of bases, you know, basises, right, plural of basis, for subject matter jurisdiction. And one of them is, guess what? Admiralty or maritime jurisdiction. The federal courts, under the Constitution, have given the power have been given the power to decide admiralty and maritime cases. That is a basis to get into federal court. And so if you're pleading a complaint that involves a maritime matter, you'll actually say, this is a maritime matter, blah, blah, blah. And that's the basis for the court's jurisdiction. And remember, now we're just talking about federal courts. We'll get into the tangent about state courts a little later. Bottom line, though, is that maritime is not the only basis to get into federal court. There are quite a number of other bases, and I'm just going to go over them briefly, talk about some of them, but they're really not the subject of this course. All we care about in this course is the basis to get in under admiralty and maritime jurisdiction. But in order to have a big picture, it's important to understand that there are other ways to get into federal court on other things. And actually, sometimes in admiralty cases, you won't plead it as an admiralty case for complex reasons, mostly because you want a jury and you don't get one in admiralty, but you might plead it under one of the other bases. So what are some of the other bases? Well, can you get into federal court under the Age Discrimination in Employment Act, or Title VII, or Americans with Disabilities Act? They're all federal statutes, and they all say federal courts can hear these cases. So that's a basis for federal jurisdiction. If you have a federal statute that expressly says the federal courts have jurisdiction to hear these disputes, then you're in on that basis. There's another very important one, and I do want you to have some understanding of this one. It's called diversity jurisdiction, and it's probably not the diversity that you think it is. I'm just going to check and make sure my vertical on the video goes that low. Yeah. Okay, so diversity jurisdiction. What does that mean? That's something that's been around since the very beginning, like 1789, when they first laid it all out. And that is when citizens of one state sue citizens of another state. They can sue them in federal court. So, for example, I have a dispute with a company in California that sent me some merchandise that was, defective, and I want to sue them. Well, I can sue them right here in federal court in New York, or I might sue them in federal court in California, but I can sue them in federal court on the basis of diversity jurisdiction. In other words, the federal court can hear it. I don't have to go to California State Court, I don't have to go to New York State Court. I can sue in federal court under diversity jurisdiction. The catch with that is that there's a minimum. It has to be $75,000. Otherwise, the court says, go away. It's not big enough for us to bother with, right? Now, if it's a commercial case with a contract, it's usually, kind of clear whether it is above or below $75,000. I did one on a personal injury where I went into federal court because the driver of the armored car was from New Jersey and the armored car company was in Maryland, and my plaintiff was in New York. So I sued on diversity. His injury was a hand injury. He was taken to the ER. Was it worth $75,000? Well, we settled for less than that, but that's not what mattered. I could easily plead it as upper edge because there's really no ceiling. I mean, you know, so nobody tried to toss the case on the idea that I didn't reach the $75,000 minimum. If it were a contract case and it was a $15,000 contract, you know, the defendants would be saying, well, you know, it doesn't belong in federal court, move to dismiss. But diversity does have a $75,000 minimum, but if it's a personal injury case, it could be, you know, it's kind of a little bit of leeway. Anyway, why does diversity matter, even for us? Because sometimes you might want to sue under diversity jurisdiction, even if it's a maritime case. This is not a core principle of the class, but it's something I want to explain to you because it brings out another aspect. For the most part, with certain exceptions, cases that are under Admiralty jurisdiction do not get a jury trial. The judge decides both the facts and the law. Ordinarily, with a jury trial, the jury is the ones who determine the truth or falsity of facts, and the judge applies only the law. Maybe gives the jury instructions about what to interpret given certain evidence, but the judge does not determine the facts. In Admiralty trials, they're usually what's called bench trials, meaning that there's no jury, it's just the judge. So the judge, one single human being, determines the truth or falsity of facts and applies the law. Sometimes parties might want to have, especially plaintiffs, might want to have a jury. And so in that case, if they have diversity, if it's like, you know, somebody in New York suing somebody in California, even though it could be in an Admiralty jurisdiction, they may plead it as diversity jurisdiction because they want a jury. So that's just a quick aside about that. Anyway, we've gone into 3 different bases for federal jurisdiction. The one we're concerned about in this course, which is Admiralty/Maritime. We're going to use those terms interchangeably. We have statutes, right? Age Discrimination and Employment Act, Americans with Disability Act, you name it. They all give you federal jurisdiction. Some statutes don't create jurisdiction, but those do. And then you have diversity. There's also federal jurisdiction if you have a constitutional claim. If you say, you know, the SUNY police are violating my First Amendment rights by telling me I can't have this flyer, you know, on my person walking around campus, you know, and by flyer I mean a piece of paper. And then you might sue them in federal court for violating your constitutional rights under the First Amendment. And that would be clearly cognizable in federal court. A federal court could hear it on the basis that it's a claim that arises out of the Constitution of the United States. So those are like the big 4, you know, Admiralty, Maritime, you know, statutory basis, diversity jurisdiction, and a constitutional claim. Those would be the big 4 ways to get into federal court. There are others, but we don't have to belabor it. Anyway, main thing we're concerned about here is Admiralty and Maritime. Questions so far? Okay. How about we review a few things just to see where people stand and I can get a sense of the room. I would like somebody to volunteer and tell me why personal jurisdiction does not matter as to the plaintiff. But you've been called on many times, so I'm going to give somebody else a chance.
Because by suing, they're already consenting to be in whatever jurisdiction they're suing.
Right. By suing, they are already consenting to the jurisdiction of the court over them. If I march into court, James M. Maloney versus John Smith, we have to worry if John Smith is subject to the court's jurisdiction, but I've already said I'm subject to the court's jurisdiction because I'm suing. And I don't even have to say I consent. By suing, I'm consenting. You know, I wouldn't be there if I didn't consent, right? So there's that. Now, I got a question for you. Suppose the plaintiff and defendant have an agreement, a contract, and they say the United States District Court for the Southern District, it's a federal court that sits in Manhattan, they have jurisdiction over any dispute arising out of this contract, right? So if they both sign that contract, even if one party is over in California and the other one's in New York, if I am now the plaintiff and I go into federal court and I say this court has personal jurisdiction over the defendant based on their agreement in the contract, should that be recognized? They've said yes. Yes, that's the answer. The answer is yes. Of course it should. Why not? They've consented to the jurisdiction of the court. Those are called forum selection clauses, forum, F-O-R-U-M, and they're generally upheld by the courts. But here's another question for you. Suppose the issue now, there's this contract, and my defendant in California has consented to the jurisdiction of the federal court, particular federal court in New York, but the issue is whether the court has subject matter jurisdiction. Let's say a contract to build a ship. And I will tell you, contracts to build a ship are not maritime contracts. It's not a maritime contract. The contract to lease or sell a ship might be, but not the building, because it's not a vessel in navigation yet. So now that I tell you that that doesn't qualify as maritime jurisdiction, do you think that the fact that we agreed that the court could have jurisdiction will carry the day, and that we'll be able to hear this case in federal court under maritime jurisdiction? I'm seeing shaking of heads. That's right. You can't consent. Parties cannot consent to the federal court's subject matter jurisdiction. The federal court has to decide whether it has subject matter jurisdiction. Parties can consent to personal jurisdiction. The defendant can say, yeah, I've agreed that the Southern District of New York has jurisdiction for any disputes arising out of this contract. It's right there in Clause 10, you know. That's easy. But nobody can consent to the federal court having subject matter jurisdiction. They either do or they don't, and that's up to the court to decide. And there's a famous case, I don't remember the name, but there was a case that went all the way to the Supreme Court, and they were disputing all these other issues. And the Supreme Court got the case and says, wait a minute, there was never federal subject matter jurisdiction in this case. So all that stuff you did, all the way up on appeal, is like as if it never happened, because the court never had jurisdiction to begin with. And that's like the lesson for all lawyers, you know. You have to make sure that the federal court has subject matter jurisdiction. Parties cannot consent to it, nobody can waive it, it has to be there. And that's going to be one of the next topics we talk about as far as whether there is or is not maritime jurisdiction. People have told me, other professors have said, don't spend too much time on jurisdiction. And I think that's a good idea. So I'm introducing it and we'll revisit it, but I'm not going to like turn it into a major topic. In law school, like I took an Admiralty law class at Fordham, and I would say about a third of the course was about jurisdiction. That much, because it's a complex topic. There's all kinds of stuff. We'll visit it. We might even read a case, depending on how things shake out with timing. I used to use this case I mentioned the first time. It's called In Re Petition of Bruce Germain. It came down in 2016, I think, or 2015. And it's a good case on Admiralty jurisdiction, Admiralty tort jurisdiction. But it's complex, and it's not an easy read. It's 30-odd pages, and you know it's a well-written opinion, but it's a lot of work. So I think what we're going to do is we're going to introduce very carefully and methodically how jurisdiction breaks down here, so that in federal courts anyway, you have to have these two. What about state courts? What about subject matter jurisdiction in state courts? Why do I say that's not so important? Anybody? Generally speaking, state courts have just, you know, I mean, every state is different, but generally speaking, the state judiciaries are courts of general jurisdiction. So in New York, and I'm going to show you the hierarchy of courts in New York and the federal system in a minute, but in New York, your entry-level general jurisdiction court is actually called Supreme, and they're county by county. So Supreme Bronx County is over there on Grand Concourse, and Supreme Queens County is over on Sutphin Boulevard, and Supreme Kings County, I think, is either on Joralemon Street or somewhere around there. You know, but each of the counties has their own Supreme Court, but that's your entry level. It's not the top court. Anybody know the name of the highest court in the state that handles the appeals at the very top? I thought you might know. You do know?
The New York State Federal Court?
No, it wouldn't be federal. It's state. State and federal are two different things. It's the Court of Appeals of the state of New York, which is confusing because in the federal system, the intermediate appellate courts are called courts of appeals. But I'm going to diagram that out in a minute. But the bottom line is, as far as subject matter jurisdiction, that's really a factor to consider in terms of being in federal court. It's not really something that's that important in state court generally. And I can say that, you know, as a practitioner in New York, I guess I was admitted to New Jersey for a while, and I know those two states, the courts tend to be general jurisdiction. You don't have to have subject matter jurisdiction to march in. You can make any case you want, and the court will decide it, but they don't say, we don't have jurisdiction to this, go away. Now, the exception to that, I should tell you, there is an exception. There are lower courts, specialized courts in most states, and New York has one. So, for example, I have a case right now, I'm waiting for an opinion on. The plaintiff is a real estate owner, and they own basically a marina over in Brooklyn. and they wanted to kick out the people who were living on houseboats there, and they served them all with these notices of eviction, ejectment actions, a specialized proceeding in New York City Civil Court in Kings County. And the judge herself actually said, I want briefing on whether I have jurisdiction over this, because this is a court of limited jurisdiction. So we did that back in the summer and argued it, and we're waiting for a decision. But there is sometimes an issue of subject matter jurisdiction in state courts. I don't want to say it never matters. But in the general jurisdiction courts, like in New York, in Supreme New York, county by county, they have general jurisdiction over just about anything. It's those lower courts, that might not have general. But, bottom line is, that's really kind of a side discussion. The main thing to keep in mind here is that jurisdiction in federal courts comes down to two things. Personal, is the defendant subject to the court's jurisdiction? And subject matter, does the court have jurisdiction to entertain and decide this type of lawsuit? Questions, and I'm going to take a quick break. And we could have questions. Come on now. Okay, we're back. The other handout I gave on Brightspace today is just a quick read, two-pager, that it's called Sources of Maritime Law. And it doesn't get into as much as we talked about as far as the three branches of government, but it does talk about sources of law, including the Constitution. So I encourage you to read that in context and see how that interrelates to what we've talked about. It overlaps, but it's not exactly identical to what I said. But the two things I put on Brightspace are just the glossary and that sources of law thing. With each week or each module, and there would be 2 modules per week, right? Because you have 2 meetings per week and my other section has 1 double. So 2 modules per week. There will be reading assigned in the electronic textbook, the Robert Force thing that's on PDF and everybody should have. And then there will also be, in many cases, maybe not all, supplemental short readings that I do. I'm not going to talk about the other upload that I did to Brightspace Now. That'll stand on its own. What I want to get into now is something that is a little vexing to students, but not all that hard to comprehend if you kind of lay it out conceptually. So let's just start with a clean slate. And don't worry if you didn't copy anything down, because it's going to be on the video. Well, unless there are technical issues, it'll be on the video. There are always technical issues. But in any event, I think it'll be on the video. And if not, we'll make sure that it's available to you. Bottom line is that I mentioned this in the Module 0, our first class on Monday. State courts can hear Admiralty cases. Isn't that amazing? Isn't that annoying? What happens then? I mean, do they apply state law? Do they apply federal maritime law? What's the deal? And can they hear any maritime case or only certain ones? So there are answers to all of those questions, and we're going to begin a little bit methodically, hopefully, by talking about how it all shakes out. First of all, very important concept in the law. Just because the court sits in a given state, or they're federal, or they're state of New York, that doesn't mean that the law they apply is the law of the forum. In other words, if I'm in New York State court, does it mean that they're going to apply New York State law? No, not at all. They might. They might apply federal maritime law. They might have to apply the law of California to a certain type of case. Judges are considered competent to apply law other than the forum in which they're sitting. So just because you're in New York court, by the way, that's true more in civil court than in criminal court. Obviously, if you're in criminal court, you're going to be charged with a crime under New York law. If you're in New York criminal court, you're going to be charged with a New York statutory crime in the penal law, right? And if you're in federal court, you're going to be charged with a crime under Title 18 United States Code, which is this whole giant list of federal offenses that if you have time, you can commit them all in one lifetime, but it's going to be a pretty big undertaking. But seriously, in criminal court, yeah, the law of the forum is going to apply because you're being charged there. But in civil matters, courts can apply law of a forum other than the one in which they're sitting. So where does that leave us with the question of admiralty law? If I'm in state court and I have an admiralty or maritime claim, should the court apply federal maritime law? Absolutely. They absolutely should. Can I bring a federal maritime kind of case in state court? The answer is sometimes. And now, when can I and when can't I becomes the question. And I'm going to probably revise a prior handout because it's a little confusing, but it's not all that complex. And to begin to explain the real key issue in making the decision whether state court can hear a maritime case, you have to look at one of those words in the glossary that I uploaded today. And that word, another legal term that has a lot of special meanings, is remedy. Remedy. And we're going to spend a few minutes now just talking about what I mean by remedy. Well, obviously, if you have a cold and you take a little Vicks NyQuil, that's a remedy, right? It's a cure for something that's gone wrong. In the law, what does remedy mean? Anybody want to hazard a guess?
It's like, well, I guess like an example would be if someone pays you back for sort of...
Money damages, right. So in other words, going back to the battery example, I knock somebody's teeth out, and they have a dentist bill for $10,000, and I pay them $10,000.
Is that considered a remedial fee?
Well, it's considered money damages. The phrase that's generally used in the law is damages. Damages don't mean the damage to you, it means the money. So we have a lot of, it's funny, the English language uses a lot of words for money, right? Damages, actually in legalese, and I'll get to you in a second, damages usually refers to money. It's a remedy. Damages means money damages. So if the plaintiff wants to be made whole, they want money. Okay, and before we go into other remedies, go ahead.
Isn't remedy also like you knock my tooth out, it costs 10 grand, and then it's like the mental damage and whatnot with it that could...
Well, right, so okay, intentional infliction of mental distress, yeah, those are all part of your claim, and if I solve that, if I settle with you, or if a jury awards you something, if it's only money, that's still one remedy, money damages. But there are other remedies. Let me ask you a question, collectively, the group here. Suppose I had grown up in a certain house in Vermont, which I did, and I have now gotten older and have some money in the bank, and I want to buy that house. And lo and behold, that house is on the market. And I go into contract with the owner of the house, and we say, yeah, he's going to sell me the house for $300,000. We sign the contract. 6 months go by, he says, I changed my mind. I don't want to sell it anymore. I said, well, you have agreed to. Under the contract, you have an obligation to sell this to me. I'll sue you. And he'll say, what are you going to get? Money? I got plenty of money. You're going to sue me? Fine, wonderful. No, I'm going to sue you for something else. I'm going to make the court order you to sell me the house because I want that house. No other house can substitute. I don't want $300,000. I don't want $1 million. I want to buy that house for $300,000 like our deal said. And I'm going to go to court and I'm going to tell the court that I want that as my remedy. I want them to order you to sell me the house as you agreed to in the contract. Can I get that? Oh yes, I can get that. It's called specific performance. It's called, in a broader sense, it's called equitable relief. Whenever a court does something besides awarding somebody money, when they actually order somebody to do something or tell them to stop doing something, that's equitable relief. Equity, the long history of it in England was that it arose separately from law. But the bottom line here is that equitable relief, including specific performance, you must sell that house to that buyer. That's all something aside from money damages, right? The court is actually ordering somebody to do it or to stop doing something. You get an injunction. Injunction is another equitable relief. The neighbor is, belching out fumes from their, oil-burning stove that's they built at home, and it burns, wasted motor oil, and the stuff is like, blue smoke coming out and blowing down on my house every day. I want to get an order to make them stop. I can do that. That's an injunction. So these are all forms of equitable relief, but that's another remedy, okay? Equitable relief, like money damages, is a remedy. So everybody clear on that? The remedy is what the court does to fix the problem. And often, but not always, it's just award damages, which means money, to the plaintiff. The defendant pays the plaintiff. Sometimes the court is ordering somebody to do something or stop doing something, and that's equitable relief. Those are both remedies. And equitable relief, it comes into many subsets. I mentioned specific performance being one where, I want to buy this specific house and I want them to perform under the contract, and I go to court and tell this guy in Vermont or I want the court to tell this guy in Vermont to sell me the house for $300,000 like we agreed to, and if I win, the court orders them to do that. And then I take title of the house, I pay my $300,000 to the seller, and they have to sell it even if they didn't want to, even if they change their mind. They agreed to, they're bound. So those are two remedies. money damages, equitable relief, but there are others. But those two are the big ones that state courts have the power to do. State and federal courts can both award money damages and equitable relief. Now, there's a whole classification of things that only federal admiralty courts can give. State courts cannot arrest a vessel. Can't arrest a vessel in New York State Supreme Court. You got to go to federal court. You can arrest a vessel. U.S. Marshals come in, the vessel's under arrest. We'll be covering that later. There's also a procedure called limitation of liability. It was based on a statute from the 1800s. It was basically to protect American shipping overseas. But if you have damage or loss to some plaintiff, could be an injury, could be damage to a bridge, whatever, you can march into federal court with a petition for limitation of liability and limit the damage to the value of the vessel. That comes under a statute, like I said, that came from the 1800s. Only federal courts can do that. You can't go into state court with that. So there are basic categories of remedies that are unique to admiralty law. And here's the big clincher. Here's the big concept. I'll get to you in a second. State courts can hear everything that state courts normally do, even if it relates to admiralty. If the remedy you're seeking is money damages or equitable relief, you can go into state court and you can plead it as an admiralty case, and they can apply federal maritime law if you want to be there. It could be a cargo claim, it could be a personal injury claim. As long as the remedy you're seeking is either money damages or equitable relief, you're fine. But if you're seeking one of these special remedies, like limitation of liability or arrest of a vessel, which ties into maritime liens, you can do that only in federal court. It's really not that hard to understand if you think of it in terms of the remedies. What happened back in 1789 was Congress looked at the Constitution, and the Constitution said federal courts have exclusive jurisdiction over all admiralty matters. But that exclusive thing has been cut down. They're not exclusive, because this first enactment in 1789, it was called the Judiciary Act of 1789, there's a thing called the Saving to Suitors Clause, and I might put a handout about that. But it basically says this. It says that federal courts shall have exclusive jurisdiction of all admiralty and maritime cases, saving to suitors, you know, those kinds of cases that the state court is competent to hear. Meaning, if the state court can grant that type of remedy, it's not exclusive anymore. The state courts can hear it. And that's the way it's been since 1789, and it's not going to change anytime soon. So state courts can hear a lot of cases that are admiralty, as long as they're not those special type of remedies, which relate to maritime liens, arrest of vessels, limitation of liability. These are things that only federal courts can do. Okay? We'll revisit that. You had a question.
I was going to ask if reform and rescind applies to admiralty law as well.
What?
Reform and rescind, isn't that another remedy? Reform and rescind.
Perform and rescind. Oh, well, all right. So those are like equitable relief under a contract, right?
Yeah.
So it's like what I was talking about with the guy who's going to sell a house. Perform. Yeah, the admiralty court can give it, but state courts are also competent to hear those. So if it's an admiralty case seeking specific performance under a contract, you know, maybe a contract for a sale of a vessel or something, and I want to sue in state court, and I want to get an order that they have to sell it under the contract, I can do that in state court. What I can't do in state court is anything that relates to maritime liens, arrest of vessels or other maritime property like cargo. I can't do limitation of liability. Those are really the big areas. But anything else you can pretty much do in federal court. I mean, in state court. A lot of times, in fact, I just got contacted on one. There'll be cargo cases in state court, just like New York City civil court, because they're like $5,000, $10,000 cargo cases. Nobody wants to bring them in federal court because the federal judge is going to get annoyed that this little case is in federal court, you know, so they bring them in state court. You can bring Jones Act personal injury actions in state court. In fact, the statute allows you to. You can seek equitable relief, generally speaking, in state court in an admiralty case. The only thing you can't do is arrest vessels, enforce maritime liens, or do limitation of liability. Those are really the big three. And the first two are kind of related because maritime liens tie into arresting a vessel. Other questions? Okay. So that lays out in general terms. Oh, I'm sorry, we're going to 2:45? Okay. I'm going to try to, since we have the video running, get the most bang for the buck and go the full distance today. One thing I will say, I may lose track of time, and if I keep going on, feel free, you're not in the camera, just go ahead and leave, and if I have a thought to finish, I'll finish the thought on camera, and whatever you missed, you'll be able to get on video, okay? So we've now talked about these concepts of jurisdiction and how that subdivides into personal and subject matter jurisdiction in the federal courts. We've talked a little bit about how state courts can hear cases relating to maritime matters and apply maritime law, but there are certain ones they can't do. Let's shift gears now and go back to the question of personal jurisdiction. What types of entities can be defendants for purposes of personal jurisdiction? Obviously, human beings, right? Every person in this room is an actual, they in the pleadings usually say a natural person, right? Human beings, they can be defendants in lawsuits, right? People get sued all the time. So that's one type of defendant that can be subject or not to personal jurisdiction. What other entities could be or might not be subject to personal jurisdiction? What artificial people are out there?
I was going to say corporations.
That's exactly right. Corporations are artificial persons, and they pretty much have to go through the same kind of standards about personal jurisdiction. You know, if you're going to sue a corporation, well, was the transaction relating to the forum? I mean, you know, if it's a California corporation and you want to sue them in New York, do you have jurisdiction over them? Do they have contacts here? Was the transaction related? A lot of complex questions under the law. But yes, corporations are the big other area. In fact, I would say it's a fair bet that probably even more litigation occurs against corporations than against individuals. But, you know, depends. Obviously not the case in matrimonials. I haven't known anybody to marry a corporation yet, but you never know. With AI, anything could happen. Anything is possible. Maybe we'll have corporate people that actually have intelligence. Not to say corporations don't, but it's a different kind of intelligence. Anyway, to get back to the track here, there is a third type of thing that can be a defendant in maritime actions and certain other federal cases. Can anybody imagine what that thing might be? Was it a hand raise or a stretch?
No,
Just stretching, okay. Well, let's actually go to the Latin here, because the type of jurisdiction I'm referring to here has a special Latin term. In rem. What is in rem jurisdiction? What does rem mean? Rem is Latin and it means the thing. It means jurisdiction in relation to the thing. Well, I mentioned that you can arrest vessels. When you arrest a vessel, maybe I'm a personal injury plaintiff and I was hurt on the vessel and I want to claim personal injury damages, and it's a little unusual, but I want to arrest the vessel. James M. Maloney versus motor vessel Fort Schuyler, her engines, tackles, blah, blah, blah. I'm actually naming the ship itself as a defendant. Can you do that? Not in state court, but yes in federal court. In rem jurisdiction over objects, physical, tangible property, is possible in federal court. So that's a third category of defendant. Now, how does the federal court get jurisdiction over a vessel? They actually have to have it in custody, or the defendant has to consent. You know, the owner of the vessel has to consent. And that's another topic for another day. But if you arrest a vessel in federal court, you're seeking in rem jurisdiction over the vessel. Is that subject matter jurisdiction or personal jurisdiction? Well, as to the question of whether you have jurisdiction over the vessel itself, that's a question of personal jurisdiction. As to the question of whether the federal court has subject matter jurisdiction, sure, it's Admiralty Maritime. But the thing is, the vessel itself as a defendant is a third category. One of three, I don't want to do it twice, three categories. An individual person, natural person, a corporation, or a thing, maritime property. It could be a vessel. There's in rem jurisdiction over vessels. That's most often what you see. A vessel is arrested. Can there be maritime in rem jurisdiction over cargo? Yes. Can there be maritime jurisdiction, in rem jurisdiction over freight money? You know, just money? Yeah. How about the fish that were on a fishing vessel? Oddball case, but I actually researched it 20 odd years ago, and yes, there can be in rem jurisdiction over the catch on a fishing vessel. Any maritime property can be subject to in rem jurisdiction in a maritime action in federal court. So what's maritime property? Vessels, cargo, the catch on a fishing vessel, freight money. Those are all maritime property. And so personal jurisdiction can extend to objects. Now, just a little aside here, has nothing to do with Admiralty law, but can anybody imagine another area of federal law where you have in rem jurisdiction over physical objects? And it usually arises in connection with prosecution of a federal crime, but it's a separate civil action that the United States brings against the property. Anybody? How about a case captioned United States versus $100,000 in cash? You see cases like that out there. What does it mean? It means that, maybe give you an example, somebody was, I don't know, this is going to be dated, I don't think anybody does this anymore, but they were driving up from Miami with a couple of kilos of cocaine. And they got stopped. Federal agents, DEA, busted them, seized the cocaine, seized the money. The cocaine is contraband. They do whatever they're going to do with it, which I think is supposed to be destroy it. But the $100,000, they're not going to burn that. So they can't just take it. So they bring a federal action. United States versus $100,000 in cash. They argue that this was illegally obtained money from committing a crime and that the United States should be able to take possession of the $100,000. And they usually win because usually these criminal defendants are busy diverting their resources to more important things like staying out of prison. So they generally don't put up a big battle. So it could be like, it could be an airplane, it could be a boat, it could be $100,000 in cash, it could be a car. But these federal civil forfeiture actions also have in rem jurisdiction. It's not as, well, it's not really related to admiralty law, but it's another example of how there can be jurisdiction over a physical object. Just as if it were a person or a corporation, the court can have jurisdiction over this object. $100,000 in cash, a boat, a ship. By the way, these federal forfeiture actions, if it's a boat, it's usually not in rem over the vessel under admiralty. It's a vessel that is being named as a defendant on the basis of this civil forfeiture action. But there may be some overlap. I don't know. I haven't gotten that phone call yet where a client has said they seized my boat and I just happen to have been in the cocaine transport business. But you never know. Maybe I'll get that phone call one of these days. But I'm not sure if I'll take the case. In any event, there are other in rem actions outside the maritime context. I think that's probably the only big example. But to get back to the point of tangency, in rem, well, actually, I had erased what I had. I mentioned personal jurisdiction. Remember, personal and subject matter are the two, I'm just going to put SJ, right? This subdivides into a natural person, a human being, and we just put human. We're not going to write anything else over here. Artificial person, which is a corporation, and a thing. And here, I'll put in parentheses Latin, in rem, and that could be, you know, a ship, cargo, etc. And of course, outside the maritime context, it could also be, you know, some other assets in a civil forfeiture case. But those are the three types of personal jurisdiction. Now, just to confuse things a little more, it shouldn't be confusing, but you just have to kind of parse it out in your head. Suppose I were suing, let's say it's a cargo case, and you know, one of the big ocean carriers, let's make it Maersk. Maersk has, you know, damaged my cargo, and so, you know, let's say my company is, you know, Fort Schuyler Shipping Incorporated, and I sue the, let's look at what the caption would look like on a legal case. I sue, oh, this is weak marker with this, Fort Schuyler Shipping Incorporated. You know, I'll call it Fort Schuyler, we'll leave it at that. But remember, the shipper is not the carrier. The shipper is usually the person who sends the cargo. Versus, let's say, we'll pick the one from, what was the name of the vessel in Captain Phillips? Anybody remember? It was Maersk, Alabama. So let's say that's the vessel that the cargo is on, and I put Maersk, Alabama in rem, and I forget what their real name is, but let's just assume it's Maersk Lines Incorporated. And here we use another alternative Latin, my voice is coming through very well on here, but let's just look at this caption. This is the plaintiff, Fort Schuyler Shipping Incorporated. The defendant damaged my cargo. That's my allegation. So Fort Schuyler Shipping Incorporated put cargo out on the MV Maersk, Alabama, which is owned by Maersk Lines Incorporated, and it's going to sue both. It's going to sue the vessel in rem and Maersk Lines Incorporated. And here's what I want to introduce. This phrase here, in personam. It's Latin. It just means in contradiction to the in rem. So this company, it's not a natural person, it's an artificial person, but I'm suing the company separately from suing the vessel. Generally speaking, in cargo cases, the vessel doesn't get arrested, somebody might, and the only way I'd have jurisdiction over this vessel, actual personal jurisdiction, is if I arrest it, or if Maersk Lines give me permission to have jurisdiction on it, which I'm not going to do. But the bottom line is I want to bring out that there will be cases where you sue both a vessel in rem and a company, the owner, in personam as well. And that's just two different defendants, obviously connected because one owns the vessel. But these are all examples of, how personal jurisdiction works over specific defendants. Again, this has nothing to do with subject matter jurisdiction, and let's just do a quick review before we wrap up of subject matter jurisdiction, because that, I think, confuses more people than anything else. Again, the federal courts are courts of limited jurisdiction, and they can't hear just any type of case. It has to be something that Congress has given them authority to hear, under the Constitution. And one of the big areas is Admiralty Maritime cases. Okay. What are some of the other areas? And I've mentioned 3 other big areas of federal subject matter jurisdiction, ways to get into federal court. Can anybody bring up one of those other areas? Yes?
Constitutional.
Right. If the case arises under the Constitution of the United States, the federal court has jurisdiction over it. So, for example, the one I gave before, one of the state police officers here sees you with a flyer that contains material that they think is, not very nice to have writing about, and then they say, we're gonna do something like charge you with a crime or whatever. I mean, you might be in federal court based on the First Amendment that you have this right to have this written material on your person or to distribute it, whatever. So that might be a constitutional claim. And of course, a constitutional claim could relate to any part of the Constitution. It could be the First Amendment, could be, the Second Amendment, could have to do with firearms, but you can get into federal court on any constitutional claim. So you have Admiralty Maritime, constitutional claims. What are the 2 others I mentioned? Bases for federal jurisdiction? Go ahead.
Diversity.
Okay, what's diversity? Diversity, it's a funny word because now people think in terms of diversity, diversity of types of people. But really here, it's an older term, comes back from the Judiciary Act of 1789, and it has to do with people residing in different states. Citizens of one state to citizens of another state. What's the dollar minimum on a diversity claim? $75,000. Everybody remembers the numbers. Speaking of numbers, the last area, by the way, is a statute. A federal statute could give you a basis to get into federal court. I will give you this to remember, and I'll answer you in a second. The Limitation of Liability Act, oddly, does not provide that there's federal jurisdiction. So the federal court has to have jurisdiction over the matter independently. Just an important point we're going to get to. You aren't raising your hand, were you? You're just stretching the cord. Go ahead.
I was going to say, isn't there a time limit also for certain cases? I guess in there.
Oh yeah, time. Well, no, there's always time. We didn't touch statute of limitations. Yeah, you mean statute of limitations and stuff like that? There's a couple of entries in the handout about that. Statute of limitations, and I also mentioned latches, L-A-C-H-E-S. You'll see that. We're not going to spend a lot of time on them in the course, but yeah, obviously those are factors that limit one's ability to get into court if the case is too old. All right, I think we'll wrap up on that note. It's 2:45. Thanks for coming. We'll see you next Wednesday.